Hi guys, thank you so much for tuning into this video once again. Today is a great day for us to talk about canons of interpretation in Nigeria. And I say in Nigeria because this channel is focused on Nigerian law. But these canons of interpretation are generally, widely accepted all over the world as how we interpret laws. What are canons of interpretation? They are the accepted means of deciphering the intention of the legislation when interpreting and applying laws. So canons of interpretation, they are also called rules of interpretation, and in this video we're going to be talking about 8 of them. 8 canons of interpretation. We'll talk about the literal rule, the golden rule, the mischief rule, the Ejusdem generis rule. We'll talk about constitution being wholly and broadly construed. We'll talk about beneficial construction. We'll talk about specific provisions overriding general provisions, and the Expressio unius rule. The Expressio unius rule. Please don't forget that if you need paid consultation, if you have a question that which answer will only benefit you in particular, if you need tailored legal solutions, you could always mail me at houseoflinstores@gmail.com or check the description box to click the link to book a paid consultation with me so that we can talk one-on-one. That creates a lawyer-client relationship between us, as opposed to you just asking a general question, because I will not be bound by the client solicitor or client advocate rules, in that instance. So, but if you have a general question that you think that asking it, the answer to it will benefit you and benefit so many others, you can leave it always on any video that you watch that is closely related to that question, or mail me at House of Living Stones as well, houseoflivingstones@gmail.com. But if you have mailed, regarding a particular issue, please don't leave the same comment. Or if you have commented, don't mail. Just do one of the two if it's a general question. Yeah, so please subscribe to the channel, like the video, leave comments in the comment section as always, and always share the videos. I appreciate those who share. YouTube shows me how the videos are shared, the activities of viewers and subscribers on the channel. Thank you. Huge shout out to the members of the channel. There are still few, but I really appreciate those who have gone a step further to pay a token, to join the channel. Thank you very much. So we're going to be talking about canons of interpretation today. In the next few videos, we're going to be talking about very interesting things. We'll talk about treason and treasonable felony. We'll talk about defamation, and we'll talk about contempt of court. We'll talk about estopel, those 4, and several other things. So much goodies on this channel. Stay tuned so that you don't miss. Now, I've said that canons of interpretation are the means by which we decipher the intention of the legislation in making or enacting any law. So the reason why we have canons of interpretation is so that we'll prevent absurdities and will prevent extremities in the interpretation and application of our laws. Because if everyone were left to apply or interpret the law the way they see fit, we will descend into a state of anarchy. So to protect and preserve law and order in the society, and to ensure a uniformity, in our interpretations and applications of laws, we have these canons, and we're going to be talking about these 8 canons today. The first is the literal rule. As pronounced or as written, the literal rule just states that give words their ordinary meaning. So when interpreting laws, don't import any extraneous meanings into words. Just give them their ordinary, everyday, mundane, general meanings. So that's the first rule, the literal rule. And the importance of this rule is so that we don't complicate or overcomplicate things, when we try to interpret laws wider or more than they actually mean, or than the legislature actually meant when they were making that law. For instance, if a law says that anyone that's 6 years old can do this, 6 should be taken as 6, just 6, 5, 6. So if you're 6 years old in age, you can do this. We don't need to say, is it 6 years at the bar? Is it 6 years of age? Is it 6 years in school? Is it 6 years in this role or not? 6 years old, that would mean 6 years of age. Generally, that's the ordinary meaning, so we should just take it like that. Let's look at a few cases that exemplify the application of the literal rule. In Baganza, for instance, the defendants were caught for a crime, and then they were tried, But at the time when they committed the crime, they were infants at law. But at the time when they were convicted, they had already become adults by the time the case got to judgment. So the court applied the literal rule to say that they would face capital punishment because they were now adults. So that's how the literal rule was applied to determine their age. Are they children at law? Should we look at the age when they were caught or the age when they were convicted? The court decided that the literal rule would apply to say that they were convicted as adults, and so they can face capital punishment. In Adegbenro and Akintola as well, section 3310 of the Constitution of the Western Region provided that the premier could remove the governor if it appeared to him that the governor no longer commanded the loyalty of the majority of the members of the house. That's the legislative house. So at the time, the judicial committee of the privy council had to determine how to interpret the word appear. How does it appear to the premier? Is it by a set of facts, how do we say it has appeared to him that the governor no longer commands the loyalty of the majority of the house? So the literal meaning was applied to mean that it could appear to the premier anyway. He could even see it in a dream or a vision, so long as it appeared to him that the governor no longer commanded the loyalty of a majority of the house, he could remove the governor. So in several other instances, the literal rule has been applied, but taking the words for their ordinary meaning, taking the ordinary meaning or imputing the ordinary meaning of words, will not always work, well. In some cases, it will descend into absurdities, as you might already decipher from some of the cases that I've cited. So the golden rule was introduced to correct this anomaly, to say that where applying the literal rule will descend the court into absurdities, let's apply the golden rule. And that will lead us to the golden rule. The golden rule is the second canon of interpretation that we want to talk about today. And the golden rule says that, where interpreting words for what they are, or their ordinary meaning, would result in absurdities or extremities, then let us try to determine the real intention of the legislature by looking at what the word could mean that could be applicable and that could do justice in this particular case. So the golden rule gives some flexibility or discretion to the courts, because the court interprets the law. We have the judiciary, the legislature, and the executive. The executive, they implement the law and they execute justice. The legislature, they make the laws, and then the judiciary, they interpret the laws. So in interpreting the law, if the literal rule will result in absurdity, let us look at the golden rule. Golden rule says that let the judiciary impute the interpretation that is closest or nearest or that best, demonstrates the intention, or that best shows or demonstrates the intention of the legislature in making that particular legislation, even if it is not the ordinary meaning of the words. So the golden rule gives some latitude to the judiciary to say that what could be the best interpretation of this law in this context. Let's go with that instead of just looking at the ordinary meaning of the word. The golden rule was formulated in the case of Beck and Smith, and the court decided that where giving the word the ordinary meaning will lead to absurdity, then let's modify the words, the meaning of the word now, to eschew the absurdity. In University of Ibadan, Adamolekun, the golden rule was applied where they had to look at the 1966 Constitution and two different sections. There was a section 3.4, that said that where an edict is inconsistent with a decree, to the extent of the inconsistency, the edict would be null and void. And then we move down to section 6, where it says that the court should not entertain any questions as to the validity of a decree. Now, if we were to apply section 6, literally the way that the law says it, that would mean that section 3.4 would be unenforceable or unjusticiable. It would mean that you cannot come to court on the basis of section 3.4, because Further down the line, the same constitution has said that the court must not entertain any matter regarding the interpretation or the validity of a decree. So if you're now saying that the court cannot do that, that means that the court cannot even begin to look at, oh, this is a decree, this is an edict, which one contradicts each other, which one is inconsistent, and what's the extent of the inconsistency. So the court applied the golden rule to say that Section 6 cannot be given effect to because it will render Section 3 for unenforceable. That will lead us to the mischief rule, the third rule or canon of interpretation. The mischief rule simply says that when interpreting and applying a piece of legislation or a law now, we must look at three things. We must look at what was the act at common law, that is, what was the law before now. Then, what mischief came up, that is, what ambiguity, what absurdity, came up with the law. Then, what this new law is now trying to correct. Then, let us look at the remedy that this new law has now brought to correct that law. That is how to apply the mischief rule. So for instance, if a law was made, that outlaws littering in a school environment, for instance, and then in the school premises, let's say the law says that you cannot litter in the school premises, and then you step just outside the gate of the school and you litter, and you're caught and you're tried under that law, and then you put up a defense that, oh, I had already stepped out of the school gates. The mischief rule can be applied to say that what's the purpose of the law? The purpose is to ensure cleanliness around the school environment. Now, outside the gate is proximate to the school environment, and you have defeated the purpose of that law, so that law can be applied to you. So that's the mischief rule. The mischief rule just helps to prevent absurd interpretation of laws. People wanting to exempt themselves because the law did not specifically provide for their particular situation. No, if what you're doing or what you have done can be safely brought under, the purpose of that law would apply to you. So that's the mischief rule. When applying it, you look at what's the purpose for which this law was made, what was the state of things before the law was made, and what's the mischief that the law is seeking to correct. So we applying this law correct that mischief anyways, even if it was not sufficiently filed or included under the classes of situations that are covered by the law. If that would be the case, then the law would apply. So that's how to apply the mischief rule. The next rule we want to apply, which is my favorite, is the Ejusdem generis rule. Ejusdem generis rule. Ejusdem generis rule just states that where a set of particular things have been stated, a class of particular things, particular events, particular situations, and it's then followed by a general provision, you must interpret that general provision in line with the specific provisions that have come before it. Very important. For instance, in Nasser and Buhari, in that case, Section 11 of the Rent Control Act of 1965 defined a premises as a building of any description which is used by persons, for living and sleeping or other lawful purposes. Now, the question that came up was night clubbing. Can it be safely called or filed under lawful purposes? So the court held that no, it cannot, because it cannot safely be interpreted as a type of purpose that follows living and sleeping. Living, sleeping is different from, night clubbing. So you cannot say that a building that's been approved for living and sleeping purposes, just because the law says other lawful purposes, even if night clubbing is lawful, you cannot safely file it under the lawful purposes permitted by the law. So that's how to interpret the Ejusdem generis. I remember that in 2021, I was asked by a government department to write a legal advice on a complaint that had been filed by a bread manufacturer or bread producer, a bread maker now, a bread factory or bread company now. So the question was that they had been taxed only taxes. Their truck was caught in town by tax force people, and they were taxed only taxes. So they had appealed to the government, written a complaint, so to speak, saying that they are not bound by only taxes because they are moving bread. they are not in the haulage business generally. They just have a truck for moving their bread from one distributor to another. So you cannot safely call them a haulage business or service that must be taxed according to the haulage tax. So I looked at the haulage tax. The haulage tax had said that people or companies, businesses that were under its taxing scope were those that were doing moving quarried stones, and all sorts things like that. It specified quarried stones. I think it talked about building materials or probably something in that line. So if I'm remembering it correctly, so I applied the Ejusdem generis rule and said that they could not come under businesses that were taxed under that section of the haulage tax law, because bread was a far cry from quarried stones, building materials and all sorts of things. So it was different, even though they were also moving produce. They were moving their bread from one distributor to another. But we cannot safely classify them as a haulage service, because the things listed are for them, are for the general provision of other like businesses, cannot even be placed beside their own business. So that's how I interpreted it. So that's an example of how to apply the Ejusdem generis rule. You look at the things that have been stated, and then when there's a general provision, an omnibus clause, coming after them, you must interpret anything you want to file under that omnibus provision in line with what has been stated beforehand. So that's the Ejusdem generis rule. The next rule is that the Constitution must be interpreted wholly and broadly. Very important. That means that you cannot interpret any provision of the Constitution in isolation. Very important. And this is because the Constitution is the ground norm. It is the mother of all laws of a state, and in Nigeria, it is the mother of all laws. All laws in Nigeria derive their powers, derive their legitimacy, and derive their source, from the Constitution. So when interpreting the Constitution, you cannot pick one section and say that this is what it says and so this is what we apply. So if the Constitution has said, for instance, that anyone who is 24 years old can be president, you cannot just say, oh, I'm 24, I can be president, make me your president. No, you have to look at all other provisions that talk about being president in Nigeria. Is there a provision that talks about your sex? Is there a provision that talks about your educational qualifications? Is there a provision that talks about your height? Is there a provision that talks about your gait? Is there a provision that talks about your eating habits as a president? Is there a provision that talks about your tribe, your religion, or any other thing? This is just an example, but you cannot just pick the age provision and say that it qualifies you to be president. You must look at all provisions. You must look at it holistically. So very important. Provisions of the Constitution cannot be interpreted in isolation. They must be linked. You must look at it, comprehensively. You must look at it comprehensively. So if you're looking for something, what does the Constitution say in every instance about this thing? What can we deduce, from combining all these provisions together? The Constitution must be interpreted wholly and broadly. The next rule is the beneficial construction rule, and that was applied in Savannah Bank and Ajilu. Please read up that case. Beneficial construction rule says that if there's a way that a piece of legislation, a provision of law has been construed, if there are ways that it's been construed and there's a broad way and a narrow way, let's always go with the broader way, to avoid absurdity and to avoid wrecking injustice. So if there's a narrower construction of a provision of law and a broader construction or interpretation, let us go with the broader interpretation. The next rule is the specific provisions rule, and it says that specific provisions if they are conflicting with general provisions, then the court should go with the specific provision. So if there are two conflicting provisions of law, if one is specific and one is general, let's go with the specific. Now, it's different from the beneficial construction rule. Let me attempt an example now. For instance, maybe the provision of law said that a woman can be president in Nigeria. That's a very wide, provision. If there's another provision of law that says that any woman who has studied in a Nigerian university for a period of not less than 5 years, who has a first degree from a Nigerian university, has completed her NYSC, is at least 28 years of age, is tall, dark, and skinny, or tall, dark, and huge, of springly gait, can be president. Now that is more specific. There's a provision, it is a constitutional provision that says that a woman can be president. Now, there's another specific constitutional provision that has listed all these qualities. To be safe, let us go with the specific provision in deciding who our president will be. So that is how to understand the specific provisions rule, which says that where there is a specific provision and a general provision and they are conflicting, we must go with the specific provision. Now, look at it this way. If we go with the general provision, do you know how many millions of women will come up and say they can be president by the mere fact that they fit that provision? But when we go with the specific provision, we narrow down, the number of people that would fit it in. And so we're able to take a step forward, in deciding who our president will be. So that is one of the benefits of sticking to specific provisions. And the last but not the least is, in this video, is the Expressio unius rule. And it says in full, Expressio unius est exclusio ulterius. Expressio unius est exclusio ulterius. The express mention of one thing is the exclusion of others. The express mention of one thing is the exclusion of others. So, for instance, if there's a piece of legislation or a provision of law that says that this waterway can only be plied by boats that are painted brown, that are 15 centimeters in width and 52 centimeters in height, manned by a boatswain of not less than 15 years boat riding experience. That is the express mention of the type of boat and who controls it that can ply that waterway. That means that any other boat manned by any other boatswain that does not fit into that express provision or description is outlawed. So the express mention of one thing in a piece of legislation is the express exclusion of all other things. So that's what I want to talk to you about in this video. These canons of interpretation help us to understand our laws better and apply them safely and judiciously. And I will see you in my very next video. Don't forget to subscribe to those.